A sponsor finishes a Regulation D private placement for a new investment fund capital raise and asks whether exempt reporting advisor status matters for the private fund management company under the Investment Advisors Act. The sponsor's view is simple. We used Rule 506, so the manager is covered too, right? Not quite. This is syndication attorney Field Notes with Tilden Moschetti. Today's Field Note is about the gap between a clean Reg D raise and the management company's advisor status. The direct answer is this. Rule 506B or Rule 506C may cover the sale of fund interests. It does not answer the Management Company's Investment Advisors Act advisor status. It also does not answer the $150 million RAM threshold. RAUM means regulatory assets under management, and it does not answer state blue sky advisor rules. Reg D protects the capital raise. It says nothing about the people managing the money afterward. That is the mistake I keep seeing. A sponsor gets the fund documents in place. The fund is selling interests under Regulation D. The investor processes plan. The sponsor feels like the fund's legal structure is set, but the management company is a separate actor. It is the company getting paid to manage the capital. It may choose assets. It may allocate money. It may decide when to buy, sell, hold, refinance, or reinvest. That manager question lives in a different legal box. Regulation D sits under the Securities Act. It is about the sale of securities to investors. It asks questions like who can invest, how are interests sold, and what information goes to investors. The Investment Advisors Act asks a different question. Is someone being paid to give advice about securities? In a private fund setting, that often means the company paid to choose and manage the fund's investments. Two different laws are doing two different jobs. Think of it like a car. The fund exemption registers the vehicle. It does not give anyone a license to drive it. That distinction matters most when a real estate sponsor changes the structure. A sponsor who raises money for one apartment building through one single-purpose company is usually managing a property. Leases, repairs, insurance, vendors, rent collections. That is real estate operation. Managing dirt is different from managing a portfolio of securities. But the picture can change when the sponsor moves into a debt fund, a fund of funds, or a multi-asset blind pool. Now, investors may commit money before the assets are known. The manager may be selecting notes, fund interests, or other securities over time. The sponsor may still think of it as real estate. The advisor law analysis may see something else. Use a simple example. A sponsor has done 5 apartment syndications. Each deal owned one building. Each deal had its own company. The sponsor handled the real estate business. Then the sponsor launches a $50 million debt fund. Investors commit capital now. The manager will call capital later and buy mortgage notes as deals appear. The fund interests are sold through a Regulation D private placement, maybe under Rule 506Z. The management company charges a management fee to choose and manage the notes. The raise may be fine as a Reg D offering, but the manager is now being paid to manage a fund that holds securities. That is the separate question. If the manager is an investment advisor to private funds, one possible federal posture is exempt reporting advisor status. Most real estate fund sponsors who land there are looking at the private fund advisor exemption under Section 203M. In plain English, that path is generally for an advisor that manages only private funds and has less than $150 million in regulatory assets under management. If the facts fit, the advisor may avoid full SEC registration and instead file an abbreviated Form ADV Part 1A. That is lighter than becoming a full registered investment advisor, often called an RIA. But exempt does not mean unregulated. An exempt reporting advisor is still reporting. It is still visible to regulators. It is still subject to anti-fraud rules. It still has fiduciary duties to the fund. Conflicts still matter. Fair dealing still matters. Telling the truth still matters. So do not read the word exempt as meaning no filing, no duties, and no regulator interest. It means a lighter framework than full RIA registration. Now, the $150 million number is where sponsors often get too casual. ROM is not the number in the pitch deck. It is not always the same as accounting assets under management. It is a regulatory calculation. One practical point: uncalled capital commitments can count. That means money investors have promised, but the fund has not drawn yet, may be part of the number. So a sponsor may say, we only have $60 million deployed, but if the fund has much larger signed commitments, the regulatory number may be higher than the sponsor thinks. That number deserves a real calculation, not a rough guess from a marketing slide. And the federal $150 million line is not the end of the analysis. State blue sky advisor rules may still matter. The main states are usually the state where the manager has its principal office, and depending on the facts, states where investors live. Some states track the federal ERA framework, some ask for notice filing, some may require a different state advisor posture. So being under $150 million at the federal level does not mean the state analysis is finished. That is the point of this field note. Do not let a clean Reg D raise answer a question it was never meant to answer. Before assuming Rule 506 solved it, ask 4 simple questions. 1. What is the manager actually managing, property or securities? 2. Is the manager getting paid for investment decisions? 3. What is the real ROM, including uncalled capital commitments? 4. Which state advisor rules apply? 2 different laws are doing 2 different jobs. Reg D covers how the money is raised. The Investment Advisors Act may cover how the management company handles the money after the raise. Final field note: the offering exemption is not the manager's license. Treat the raise and the manager as separate questions, and the structure becomes much easier to read.